morning, everyone, distinguished guests, ladies and gentlemen. It's my honor to be here. And let me introduce a bit about myself. I'm an external speaker from IP Key Southeast Asia IP SME Helpdesk. And I will be introducing the new revised IP law with some comments on how businesses, including European businesses as well as Vietnamese businesses, can use the IP law to boost the economic growth. So let me briefly introduce about Southeast Asia IP advice for European SMEs. This is an initiative of the European Commission, which provides free, confidential, business-focused advice to small and medium enterprises and relating to IP rights in Southeast Asia. This is a snapshot of Helpdesk free services, including 4 services. Inquiry helpline. You can send any IP questions relating to Southeast Asia to the Helpdesk and receive a reply within 3 working days. The Helpdesk organizes monthly training workshops and live webinars, which is tailored to the need of SMEs across Europe and Southeast Asia throughout the year. They also have a publication in terms of country fact sheets, industry-specific IP guides. So you will find information relating to Vietnam, Thailand, Indonesia in the country fact sheets in the publications. And last but not least, the Helpdesk also offers interactive learning tools, for example, e-learning modules, which are also available for download from the official website. This is also a very special feature of the IP SME Helpdesk, which is one-to-one consultation. And you can schedule an online meeting with the IP business advisor, Benoit, and he's here today. To learn more about how to protect and enforce the intangible assets when doing business in Southeast Asia. The consultation is 100% free of charge. And easy to book via the provided link on the slide. And finally, just to flag about the Green Economy Forum and Exhibition 2024 this year. It will be from the 21st to 23rd of October this year in Ho Chi Minh City. And please refer to the slide for more information. Okay. This is the brief agenda of my presentation today. There will be 2 main parts. First, relating to IP prosecution, and second part relating to IP enforcement. And please do interrupt me if you have any questions, because I have pretty like many slides to cover, given the overhaul of the IP laws in Vietnam, so cover many issues, and hopefully it will be quite easy to take away from the session this morning. So first of all, about IP prosecution. I will cover 2 parts here. First, about patent prosecution, and the second part is trademark prosecution. For patent prosecution, we receive a lot of inquiries coming from businesses relating to first filing requirements. So this is stipulated under the IP law, as well as the guiding decree to implement the IP law, the Decree 65. So what does this mean for businesses? If they have inventions created in Vietnam by Vietnamese citizens or an organization established under Vietnamese laws, there are some important notes to do before they can file the inventions overseas. So the takeaway is, if such inventions created in Vietnam by Vietnamese citizens or by an organization established under Vietnamese laws, then you should file in Vietnam first before going abroad. If that invention or utility solution falls under the first to file obligation. So of note, if the invention or utility solutions are in certain technical fields impacting national defense and security, then or where device or technology have dual civil and security applications, then filing in Vietnam first is required. Moving on to trademark prosecution. First of all, recognizing well-known trademarks. This is also a very important topic that we received a lot of questions about how to recognize well-known trademarks in Vietnam. Um, and second, how to enforce it. Because most of the times when a well-known trademark is already been recognized elsewhere, for example, in Europe, or US or in some other countries, and the business expands to Vietnam, there is a need to also recognize that well-known trademark and also to enforce it in practice because some uh, businesses here or even some individuals, they can just use the trademarks, the well-known trademarks, for sometimes identical goods or services, or sometimes even unrelated goods or services which severely impact the reputation and the well-known status of that trademark. So we welcome the changes under the current IP law, the revised IP law, which we hope would facilitate the well-known trademark recognition, including specify public perception in the well-known trademark definition. So there is a requirement of public perception inserted in the definition of well-known trademark. The law also solidified criteria for well-known trademark recognition. So under the revised IP law, there is a list of criteria for well-known trademark recognition, and the law also makes it clear that certain criteria, when certain criteria are met, then it is also sufficient for well-known trademark recognition, and it doesn't have to be the case where all of the criteria are met to recognize a well-known trademark. However, we just flag here some recommendation for businesses, which is maybe some advocacy is needed for a specific mechanism for IP Vietnam and the court to recognize well-known trademarks. Because in order to implement the provision under the IP law, then we would need to really ask the question, who would be the authority to recognize well-known trademark, whether that is IP Vietnam or the court, and what is the procedure for IP Vietnam and the court to recognize such well-known trademarks. The second important thing is keep detailed records, given the evidentiary requirements to recognize a trademark, a well-known trademark. So it is necessary to document the trademark's reputation, use, and recognition thoroughly, especially in Vietnam. And last but not least, stay in touch with authorities, consult with government authorities, enforcement authorities before any official decisions are made, and also having a strategic plan to protect your well-known trademark when you operate in the country. About sound marks, so for the first time, the amended IP law provides protection to sound marks as well as relevant grounds for refusal. So these changes makes Vietnam more consistent to protect given the IP registers already there. The amended for trademarks only 3 years. If the trademarks are expired, it can only be cited to reject later filed trademarks for only 3 years. And also, this is also a very welcoming changes under the revised IP law, which allow temporary suspension of examination, which means that if you are the applicant and file an application before IP Vietnam and got rejected because of an expired trademark, then you are allowed to ask IP office to suspend temporarily the examination until that 3 years period pass, and there is no longer required to refile your trademark. This is a new ground, misleading use and genericization. This is a new legal ground to invalidate a trademark registration. The law provided that a trademark registration can be cancelled if the trademark is used in a manner that misleads the public as to the nature, quality, geographical origin of goods services, or become the common name of the covered goods or services. So key takeaways. Sorry. Key takeaways here. Both owner and consumer should have better control of trademark usage to avoid misuse and genericization. And the trademark indications such as R in the circle or the symbol TM for trademark should be used next to the trademark itself to help avoiding genericization. This is also a new practice before IP Vietnam that pending applications are no longer cited to refuse later filings. So before, even pending applications of a third party can be used to reject a pending application in before IP Vietnam. However, it's now changing to the new practice, which means that IP Vietnam only cites registered marks as citations. Um, and with an exception to IRs, because the examination procedure is limited to only 12 months, so very short period of time, just a year, IP Vietnam will still continue citing prior pending marks in the provisional refusals. However, again, the applicant is now equipped with a right to request IP Vietnam to postpone the examination of their trademark until the status of the cited mark is determined. So this means that the shift to citing only registered marks created a more predictable environment for applicants because the online database of IP Vietnam published all the registrations, the trademark registrations that are granted in the IP registry, as well as pending applications. There are some delay in publications of pending applications, because there are maybe delay between the internal communications or some errors, mistakes along the way. But shifting to only rejecting a trademark application based on registrations means that any applicant, before filing their trademarks, they can go to online website of IP Vietnam, look into the database to see, what are the possible citations, meaning the registrations can become obstacle to their pending application before actually filing the application. So this is a very good change that we very welcome. In terms of bad faith filings, this is also very important for foreign businesses when doing business in Vietnam, because their trademarks may have been used in other countries, and the business now expand to Vietnam. However, only when they look at Vietnam market to expand their business, they find out that they're actually applications or even registrations registered by a bad faith filer. which is aware of their trademarks and file an application to register the mark with IP Viet Nam before they do so. So before bad faith filings is used only a reason for extending the time frame to initiate an validation, and it's not a legal ground to invalidate, oppose, or refuse a trademark. However, with the amended IP law, it's now a legal ground to invalidate a registration and even much earlier to oppose an application which is still pending before IP Viet Nam. And this is a very effective tool for trademark owners, the real owner of the trademarks, to stop the application filed in bad faith. However, there is some challenges in terms of proving the reputation of the trademark itself, as well as the trademark owner's reputation, because in order to establish bad faith, the trademark owner needs to prove that they actually have reputation elsewhere, and the bad faith filer is aware of those reputation in order to file the application in Vietnam first before they have the opportunity to do it. So just a quick flag here that this is a challenge, sometimes a challenge for trademark owners to collect evidence and documentation to prove the reputation. This is the another part in IP prosecution, which is relating to opposition procedure. And there are many changes into the time frame of the opposition procedure, which in turn have some implications for trademark owners to oppose against third-party filings. So in a nutshell, there are two ways or two separate procedures that you can select to oppose against a pending trademark or design application. So first of all, the opposition procedure. This is a recommended procedure to use when you want to oppose a trademark application. However, the time frame to file opposition is now shortened to only 5 months from the trademark publication, or that is for trademark, and for design, 4 months from the industrial design publication. So the implication is businesses now need to monitor the IP Gazette, the publications, very closely in order to file the opposition, because it is only 5 months from the publication for trademarks and 4 months for design applications. Why we said it is recommended? Because there are steps to follow in that procedure. For example, IP Viet Nam, they will review the opposition petition submitted by businesses, and they can invite opinions or submissions coming from the applicant, and then allow maybe a round of submissions from both sides before finally decided on whether to allow the pending application to register. If you miss the time frame to oppose, then there is another procedure, which of course have more time to do that, but it's also less ideal because it's just a third party opinion, which means that IP Vietnam only uses as a reference. It does not have to respond to the opinion submitted via this way. And so, if you miss the opposition procedure, you can still buy some opinions for IP Vietnam examiners to consider. But of course, this means that IP owners should now really invest in time and effort in monitoring and take necessary actions against conflicting marks or design in time. Now coming to the second part of my presentation, which I plan to spend a bit more time, which is about IP enforcement. Copyright ownership presumption. This is relating to copyright enforcement. And from our observation, it's still quite difficult to enforce copyrights and related rights in Vietnam. And this is a new provision under the revised IP law, which provided that individuals or organizations named in the usual manner, for example, name appearing on the original work, first fixation of performance, etc., shall be deemed as the right holders, because copyrights are automatically protected without the need of registration. So the principle of presumption of copyright ownership is also suitable to assist copyright owners to enforce their rights. I'm going to talk a little bit more about administrative actions against IP violations, given the changes under the revised IP laws, as well as given that administrative measures are still mostly used by IP owners when they seek to enforce their IP rights on the ground. So recently, there is Decree 46 issued and introduced some significant changes covering issues, for example, authority overlapping or some legal gaps in dealing with recently emerging infringing acts. For example, some changes include fine for new infringing acts now set out in the amended IP law, which means that there will be now fines for the new infringing acts, covered under the revised IP law. There's also important change relation to domain names, and this is the area where a lot of businesses struggled with. So the new law, the new IP law, amended IP law provide, and this is the guiding decree, provided that the law enforcement authorities now can request VNIC, which is Vietnam Internet Center, under Ministry of Information and Communication, as well as domain registrars to coordinate, provide expert opinions, and especially to maintain the status quo for the domain names at issue at the process of handling administrative violations. So why this is important? Because in practice, there are a lot of instances where the owner of the domain name, for example, when they see a well-known trademark, let's say BMW or Coca-Cola, for example, and they register the domain name, including the exact version of the trademarks. Now, when the owner of BMW or Coca-Cola wanted to claim the domain name back, sometimes they struggling with the procedure because firstly, the owner of the domain name and the website linking to the domain name, sometimes they put the website inactive, or they linked the website into something totally unrelated. Maybe advertisement for um, property or selling different goods or services. And under the current practice, it would be very difficult for trademark owners to prove that there is actually unfair competition going on, infringement of their trademark going on, in order to persuade law enforcement authorities to issue a decision to transfer back the domain name to the trademark owners. So with that change, this means that enforcement authorities, when they're hearing the dispute, they can order the Vietnam Internet Center or domain name registrars to maintain the status quo of the domain name, which means that no change to that domain name and website is allowed, so that they can resolve the case and consider the case. So this is also very important and supportive of the effort of trademark owners when they're dealing with domain names infringement. We also found that, of course, yes, of course, there are changes under the Decree 46, introducing new fines, and still administrative measures are mostly used by IP owners. But we've also been talking about that quite a while, that IP administrative options only suitable for very straightforward IP disputes and not for complicated case. For example, for uh, you know, patterns, industrial designs, or even, unfair competitions. It is more suitable for civil litigations. And so um, it also, the businesses, we hear from the businesses that there should be a shift to civil litigations, or at least making civil litigations as popular choice as administrative measure, so that they can have more options to select whenever there is a dispute coming up and there is a need to resolve that to protect legitimate and interest of the right holders. There is also another thing we would like to flag in connecting, the use of administrative measures, and the need to address infringement on e-commerce platforms, because what we've seen right now is the lacking of connection between administrative authorities. For example, the DMS, the Market Management Bureau, and Economic Police, with e-commerce platforms. So I'm talking about online to offline enforcement, because naturally, when infringer wanted to sell their goods or services, they would like to sell them online as well. So they register user accounts on e-commerce platforms to advertise and offer for sales of their goods and services. If administrative authorities just focus on physical rates, physical inspection, um, and sometimes it's also very hard to do that because they need to file the warehouse, they need to file a physical shop in order to do the raid. But it doesn't um, ultimately resolve the problems, because there's still the online sphere where, a lot of activities like live streaming, like, advertisement offering for sales happening every minute. um, and so there must be something to be done here to connect, online to offline enforcement, um, so that, it can resolve completely the issues. um, and there is also a need for enforcement authorities to work with e-commerce platforms to order them, to hand over some information such as, the owner account information, their names, their phone numbers, so that enforcement authorities can further inspect and can match the user accounts on e-commerce platforms with actual shops or actual individuals or organizations in the offline environment to do inspections and raids. Um, yeah, so this is just the slide continues what I've just shared about more attention to domain names and online enforcement. Um, and more efforts needed to be completed here, given now the booming of e-commerce, and also the complications of selling counterfeits and infringing products online. um, yeah, and in terms of observing the platforms, so the e-commerce platforms operating in Vietnam, and directly working with them. For some IP owners, we can share some experience here that they are quite passive in taking actions. Um, and mainly the actions are based on right holders notice and take down request. So they don't really proactively monitoring the platforms and take preemptive actions to remove infringing listings, because they should have knowledge about you know some goods or services, and you know and of course they can um, like aware of the main trademarks, well-known trademarks, whatever, and they can put some algorithms into the internal web system, so to you know um, take some preemptive actions before IP owners had to do that. And also, they also very passive too in the case where the right holders need to file several notice and take down to the same user account or to the same listings, because what it happens in practice was when the listings were reported to e-commerce platforms and e-commerce platforms agree to remove, then it just been removed for several days, and then maybe a week later the user's account still posting those listings online, and the IPO owners spotted that, and they need to file again and again. So that consumed a lot of effort, and also expenses for the right holders. And sometimes the e-commerce platforms also acting pretty much as enforcement authorities require a lot of documentation from right holders, so that they can see, well, this is infringement, well, this is not infringement, we need this, we need that. And so that creates a lot of issues and problems for IP owners. And so like we really hope that there could be some efforts here, to make the e-commerce platforms, which become more important stakeholder in the enforcement landscape, to take some steps to do their jobs, and helping enforcement authorities as well as right holders to in the fight against counterfeit and infringing products and services. Another issues in the enforcement against IP infringement is expert opinions, and we would like to bring this issue up for discussion, because under the laws, expert opinions are not compulsory to support a complaint against IP infringement. However, IP owners usually need to request an expert opinion before they can come to enforcement authorities to request to handle the case. And practically speaking, enforcement authorities wouldn't handle the case if there is no expert opinion submitted by IP owners. Um, so of course, we understand the need of having some sort of guidance or reference, but we really hope that with the time, as enforcement authorities deal with more and more enforcement cases, they will also, they also expected to have more experience in deciding themselves without the need of having expert opinions that this is infringement, this is not infringement. Um, and I will share about the difficulties of IP owners when obtaining expert opinions in the next slide. So firstly, and some IP owners bitterly complained that they need to not just asking expert opinion once but twice. And this is really redundant. Why? Because, for example, market management bureau officials, when they do the inspection of a physical shop and they see all the counterfeits based on the complaint from IP owners and also based on the first expert opinion, um, uh, obtained and submitted to enforcement authorities by IP owners. When the official sees all the infringing goods, and they would need to review, oh, this is infringement or this is not infringement. And even though there is already the first expert opinion submitted by IP owners, enforcement authority now requests a second time that IP owners should ask the second expert opinion to confirm the seized products and confirm that the seized products are actually counterfeit or infringing goods. In our view, this is not necessary because there's already the first expert opinion and the goods are identical. The complaint, in the complaint, the goods there as well as the seized goods in the actual step when authorities seize the goods are identical. There is no need to have the second round of expert opinion because that is a waste of resource, and it is not really needed. And so, so that is the requirement from enforcement authority right now, and also the difficulty complained by IP owners for the moment. There is another issue here because sometimes the infringers, they also seek to request the expert opinion from IP Viet Nam, because usually VPRI, Vietnam Intellectual Property Research Institute, is the default agency to issue expert opinion to guide enforcement authority at the request of IP owners. Now, if they see the first expert opinion and favorable, the infringer doesn't agree, and it seeks to obtain another expert opinion from IP Vietnam. And we actually come across cases where these experts' opinions are conflicting. So VP said, yes, this is infringement. IP Vietnam say, no, this is not infringement. And enforcement authorities sometimes, and we also saw that in practice, they need to hold a meeting. They also invite IP Vietnam, VPRI, and MOSD, Ministry of Science and Technology experts, and ask, so what is the conclusion here about infringement? So, you you can see that asking expert opinions sometimes is very complicated and involves a lot of rounds and creates a lot of uncertainty for IP owners when trying to enforce their rights. And, hopefully, because under the laws, expert opinions are not necessary. It is not a compulsory document needed for enforcement proceedings. Then hopefully, in the coming time, authorities would be more confident to handle the case without having the need to seeking expert opinions. So this is coming to the end of my presentation. I'm just flagging the plan for specialized authorities to handle IP matters. I'm talking about the specialized IP court, which Vietnam currently has in plan. So from what we've heard recently, there is initiative to establish an IP court in Hanoi and Ho Chi Minh City just to handle IP disputes cases only. So we really hope that this plan could be realized and implemented in the short coming time, maybe in the immediate future, so that as I said earlier, civil litigation should be another venue for IP holders to voice their concerns, to bring their disputes there, to resolve, and make it at least as popular as the administrative channel. Okay, so the last part, just the takeaways. would be a summary of what has been shared during the presentation. So if you have any questions, please feel free to text us via emails. Um, and we would be very happy to receive your questions. Thank you very much.